Yeah, that is one of the challenges to these cases. You're dealing with witnesses, police officers who testify in court all the time. In fact, they have training as to how to testify in court, how to look at the jury, the whole bit. And I even asked them a few questions about that in the examination. But the reason that I thought this would be a good case, Dan, because first couple cases we looked at, there were great cases. A lot of people thought, you know, it was a great result, which I appreciate. But for me, those are like some of my easiest cases. And most of my cases that I've tried are much more difficult. They have weapons, for example. They have really difficult facts. And so I thought, because there's a pipe in this case, and because the allegation is the decedent was coming at the officer with the pipe, and in the officer's mind about to strike him in the head with it from a short distance away, and there were no witnesses, this would be a good case to kind of show why we decided to take the case, what we did in discovery, how we opposed summary judgment with no witnesses, and then how we eventually got it to trial, our strategy, and how we won the trial. So, you know, when we first got the case, and we talked about it before, we're trying to decide, should we take the case? Can we survive summary judgment? And we only knew that he allegedly had a pipe and was coming at an officer and there were no witnesses. So what we really wanted to do is get the officer's statement, look at the autopsy report, and look at photos of the scene to try to figure out how we could put together not only an opposition to the MSJ, but eventually how we could possibly win the case at trial. Objectively, you know, you got a guy with a criminal history, 10 DUIs, evading, under the influence of drugs and alcohol, pipe, no witnesses, and, you know, we knew it was going to be difficult. And I knew, like in most of my cases, as I've been talking about, I had to focus the jury on what I wanted them to focus on. I had to frame the case and focus on whether it was an immediate threat of death, not on whether the guy was acting like an idiot, you know, drinking and doing drugs and driving and grabbing a pipe and doing whatever, not obeying verbal commands. So I was thinking, you know, what am I going to ask during jury selection? How am I going to deal with the negative evidence? And how am I going to frame the issue in jury selection, which we're going to go over some of that in a moment. And then the opening, my first chance to talk to that jury after jury selection. How am I going to frame the case? How am I going to empower them to see the case my way? And then my first witness, Dan, was Shipman. And as I told you off the record, I believe, when we were having one of our prep discussions, I think effectively cross-examining the police officer in these cases is critical. And it's probably an area where a lot of people feel maybe like they can improve, right? Because they're professional witnesses. How am I going to be able to call them first and score points with them? And I'm going to give everyone some points on how to do that. Now, this is important. So a lot of people that aren't civil practitioners don't really get this, but some of my key points I could give to you on MSJ opposition. Generally speaking, you want to dispute as many facts as you can. The more factual disputes you could create, the less likely the judge can grant summary judgment. Because the whole theory is, based on the undisputed facts in this case, and applying the law, the defense should win. But if the facts are disputed, the judge cannot do that. So when they send their separate statement of 30 undisputed facts, you got to use circumstantial evidence and be creative with disputing as many of those as you can. Then you get to add your additional facts, showing additional facts to the court, including factual disputes. Now, the other important concept is the judge is supposed to assume all your facts as true. They're not supposed to weigh the evidence on a summary judgment. They got to not only assume all your facts are true, but they got to take all reasonable inferences from your facts. So if you're arguing at motion or even before the Court of Appeals, you remind them that this is the standard, and then you say, assuming all our facts and taking all reasonable inferences, here's how it happened, Judge. You got to assume that's how it happened. I'm telling him, see, I'm already framing the case. The first thing I tell him, the main issue in this case is going to be whether the use of deadly force was appropriate or not. Now, you'll notice as we go through the opening and closing and rebuttal, that transitions to, was it necessary to shoot and kill him? To, was it necessary to kill him? To, did he deserve the death penalty? I mean, I'm pushing it to have it be a question I could win. But here I'm being very neutral. That's the issue. And I asked them, is there anyone on the panel that feels, for whatever reason, they would not be comfortable with deciding that issue? No response. Then I go to the next issue. One of the issues may be whether there were other reasonable alternatives other than using deadly force. Anybody uncomfortable with that? No response. So already from the beginning, I'm telling them two of the issues are, did you have to use deadly force, and were there other reasonable options? I want them to be thinking about that from the beginning. Now I want to touch on some of my negative evidence. All right, now, opening statement. Now, a lot of people say that trials, most jurors get their impression one way or the other from opening statement. I mean, you probably heard statistics on this, right? Some people think the opening statements, the case is won or lost in opening statement. I wouldn't go that far, but I would say it's very important, opening statement. So here we talk about framing the case or setting up the issue to be a factual dispute you could win. I'm telling them in my opening, the issue in the case, as I briefly said in jury selection, is whether the use of deadly force was appropriate or not. Okay, now that transitions a little bit, whether they needed to shoot him, whether they needed to kill him, whether it was necessary to kill him. But I'm just starting to get their attention. So some of the evidence you are going to hear, both from the officers and, as the judge alluded to, police practice experts, is when can an officer use deadly force? What are the standards? What are the rules? What are the principles? Now, during jury selection, the judge said, well, we might have police practice experts here. So I like to include the judge in the conversation. I hope people that are watching, my approach, in my opinion, is very simplistic. It's something anyone could do. I mean, I have experience in doing it, and I probably do it pretty well because I've done it so many times, but it's very simplistic. I'm telling them there's some negative evidence. I'm telling them what the issue is. I'm letting them know the standards. I'm empowering them. I'm pointing out inconsistencies. I'm pointing out what to look for, and I'm giving them a picture. In my opinion, if you do a good opening statement, and the juror should be thinking, okay, I like this lawyer. They explain things really well. They're prepared. And if it happened, if what they're saying is true, they should win this case.